It is uh, January 24. Yeah, January 24 here in the Philippines. It is actually around 5:20 in the afternoon. Now, this channel is, as you know, also devoted to prepping, survivalism, etc. And related to prepping is the need for some kind of bug out or a kind of escape route, a land. We earlier said the importance of land during this pandemic, during some kind of an emergency. Preppers call it shit hits the fan. You know, the importance of land is paramount, very very important. Now, the question now is, what if someone built on your land, or what if someone built on your land? By the way, I'm Jason, your host, and this channel is devoted to current events, literature, rock music, the outdoors, martial arts, blade culture, and as we said, prepping and survivalism. And our topic is related to prepping in survival and survivalism, in the sense that in prepping, there's a need for land, okay, for bug out. But what if your land, hi there, Miller Gilbert. So thanks for dropping by. What if your land is, occupied by someone else? Um, it's very because it can happen that during an emergency, when you finally decide to go to your bug out location or your land, you find out when you realize that someone else has built this particular situation or topic. Most preppers have this kind of philosophy that um, they ought to avoid, or we ought to avoid skirmishes with the law. Yeah, uh, confrontation, debates, and actually avoid getting into situations where uh, confrontations will have to happen. But then again, still we are guided by law and order, even if we are independent, and even if we are independent thinkers, and we ought to fend, or we ought to help ourselves in some situations. um, of course, if there is someone in your land, that person ought to be a builder or a planter slash sower in bad faith. He is in bad faith, or she is in bad faith, because that person, perhaps without building permit or anything, that person, without considering that that particular land could be owned by someone else, built built an edifice or a structure in that land. So therefore, he is in bad faith. And under our civil laws, there are several consequences for being a builder in bad faith. For instance, you get no right whatsoever. You don't call the shots. You have no options, and in fact, you can lose the structure, and uh, you can be, tasked to to destroy the structure at your expense. Plus, you have to also pay the owner of the land damages. You are in bad faith because you are very much aware that the land is actually not yours, yet you built something there. Okay, so you are in effect in bad faith in that regard. Now we look into other pertinent provisions of law, particularly the Constitution, the Building Code, Issue of Business Act, etc. Uh, in dealing with, because there's a need for a building permit, before you actually construct something. And there are so many questions or so many factors that could make you know the construction possible. One of which is, there could be possible corruption in the person able to build a structure, even if he has no building permit, and was able to, you know continue the construction even without such building permit. So let's look at some pertinent laws. First, we have the Philippine Constitution. By the way, this video will be uploaded here as a non-live video. I'm recording or streaming live right now. Of course, the Philippine Constitution, as per our policies declaration, is Article 2, Section 4. It says that, hi there, Madam Inupa. It states there that the state recognizes the vital role of communication and information in nation building. Communication, very important. This is important because when you finally decided to sue the person, you might need the information coming from some government offices, particularly the municipal engineer or the city engineer. So the city engineer, municipal engineer ought to cooperate with you in giving you information. Okay, Section 27 of the same Constitution, it says that the state shall maintain honesty and integrity in the public service and take positive and effective measures against graft and corruption. And as we said, the uh, office that is tasked to monitor all these structures in building and constructions uh, is the municipal engineering office or the city engineering office. So they ought to be, doing their jobs well. Of course, there's a that they're doing their jobs properly and well. But there could be possibility that there could also be a little bit of, graft and corruption if in case a particular construction actually, you know, proceeds to its completion without the said office, with the engineer's office stopping it. Section 28. Subject to responsible conditions prescribed by law, the state shall adopt, or the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. So we will now ask if there was building permit. Was there building permit? So you will ask the public office, the engineer's office. So there must be public disclosure. Yeah? That the office ought to cooperate and actually provide information regarding your query, especially if it's about building permit. Article 3, Section 1. This is already part of the Bill of Rights. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Now we're talking here of property in case some person builds a structure property. So this is about property, and no one shall be deprived of property without due process of law. And if someone, constructs a building in your land, you're deprived of your property, and that's without due process. There ought to be due process. There ought to be some, government machineries, legal machineries, where you can actually retrieve, reconvey, get your property, and actually, uh, have some, uh, have some uh, award of damages. Section 7 of the same constitution. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizen subject to such limitations as may be provided by law. So we are here still in the Constitution, still about access to information. So if you want to get information from the uh, engineer's office, the office ought to cooperate and give you the information needed with regard to such construction or illegal construction. Section 1, Article 11, public office is a public trust. Public officers and employees must at all times be accountable to the people. So some of them, or serve them with utmost responsibility, integrity, loyalty, and efficiency. Okay, act with patriotism and justice, and lead modest lives. So this provision that is against corruption and all that. So Section 4. The present anti-graft court, known as the Sandigan Bayan, shall continue to function and exercise its jurisdiction as now or hereafter may be provided by law. So the Sandigan Bayan is actually the one with jurisdiction as per, uh, you know, government employees or elected or otherwise, when the case is related to their office or office related. Or for the military, it's the court martial. Of course, Section 5, there is hereby created the independent office of the Ombudsman, composed of the Ombudsman, to be known as Tanod Bayan, one overall deputy, and at least one deputy each for Luzon, Visayas, and Mindanao. A separate deputy for the military establishment may likewise be appointed. As we said, uh, for the soldiers, for the military sector, they have the so-called they have the court martial. For other people, we have the prosecutor's office. But when we are dealing with uh, misgivings of or crimes and offenses by public officers, we have the ombudsman. Again, section 12 from the same constitution, again about the ombudsman. The constitution says that the ombudsman and his deputies, as protectors of the people, shall act promptly on complaints filed in any form or manner against public officials or employees of the government, or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations, and shall, in appropriate cases, notify the complainants of the action taken and the result thereof. Now, this is about the ombudsman, the duty of the ombudsman. Hi there, Madam Minjo Park. Thanks for dropping by. We're talking about prepping, about lands, and about illegal constructions. We are quoting some pertinent provisions of the law, and we are now quoting the Constitution. Section 13, the powers and functions and duties of the Ombudsman. Of course, there are so many powers and functions, but we will mention a few. Okay, there's Section 13, Item 1, investigate on its own or on complaint. So it has a power to investigate on its own or on complaint. So for example, you figure that in the illegal construction, you feel that the government officials concerned committed some kind of malfeasance, okay, or misfeasance or non-feasance. You can ask for help from the ombudsman, because ombudsman is tasked to investigate on its own or on complaint. So even without complaint, and may even recommend removal, suspension, suspension, demotion, fine, censure, prosecution of that officer, public officer, and ensure compliance of the law and of some directives. We now go to a particular executive order from the Constitution. Let's go to issuance by the office of the president. Technically, this is not a law. This is a kind of a quasi legislative act of the uh, executive branch of the government, because as per the administrative code, the executive branch is deemed to be the expert, okay, the expert in execution of the law, and how the law should be executed, or when it shall be executed. Therefore, the executive branch has quasi legislative power. It can actually create implementing rules and regulations related to some laws, and it can actually issue, it can actually issue circulars, of course, issuances. The president could also issue executive orders, particularly this one related to our Executive Order 2/16 on freedom of information. So the public ought to be informed, right? So this is something that is, you know, from the office of the president, that's related to the freedom of information. Because there was of information bill, but I don't think uh, it actually got passed as a law. But we have the freedom of information uh, as executive order. Okay, definition. Section 1 of said executive order. Information. What is an information? Shall mean any records, documents, papers, reports, letters, contracts, minutes, and transcripts of official meetings, and maps, books, photographs, data, research materials, films, sound, and video, magnetic and otherwise, and other tapes, electronic data, computer stored data, any other or similar or materials recorded, stored or archived in whatever format, whether offline or online, which are made, received, or kept in or under the control and custody of any government office pursuant to law, executive order, and rules and regulations, or in connection with the performance transactions of official business by any government office. So that's information. So that's the information that we can actually request from the government. Of course, there are some rules regarding it. Information cannot be made public, for instance, when it pertains to public security, you know, or government secrets, security related, military related. As Section 2, the coverage, we're talking of Section 2, the coverage. It covers the executive branch. Does it include the local government? Yeah, LGUs are actually just encouraged to observe and be guided by this order, because there is the so-called the rule on LGUs being a little bit more or less with some kind of autonomy. So Section 3, access to information. Every Filipino shall have access to information, official records, public records, and to documents and papers pertaining to official acts, transactions, and decisions, as well as to government research data used as basis for policy development. So this is actually based on the Constitution. We actually quoted the Constitution earlier. There was mention of government research data used as basis for policy development. The public actually ought to have access to those information. Now let's proceed to Section 6. Application and interpretation. This shall be there shall be a legal presumption in favor of access to information, public records, and of official records. No request for information shall be denied unless it clearly falls under any of the exceptions listed in the inventory or updated inventory of exceptions circularized by the Office of the President provided in the preceding section. There's actually a list. Okay, let's proceed. In making such determination, the head of office or his designated officer shall exercise reasonable diligence to ensure that no exceptions shall be used or availed of to deny any request for information or access to public records or official records if the denial is intended primarily and purposely to cover up a crime, wrongdoing, graft, or corruption. So, the presumption is information is public and information ought to be given, and heads of office and other officers ought to make sure that the information is disseminated or made available to the public. And there's a presumption that if you do not, then that's a kind of an act to cover up a crime or graft and corruption. So the head of office must make sure that information is available to the public, and it's not being, you know, it's not being made classified by virtue of a cover up, particularly of a or of graft and corruption. And according to Executive Order 2 series of 2016, they have 15 days to respond, and extensions must not go beyond 20 days. Of course, there's administrative liability, criminal, etc. So section 15. But we will proceed to other laws, and we will find out that these 15 days will be shortened. You know, then let's check our notes. Can proceed. This is so-called Anti-Red Tape Act or Republic Act 9485, which is also pertinent to our. But this law was amended as Republic Act 11032 on July 24, 2017, and became the Ease of Doing Business Act. Hi there, Manoy Alec, official. Noah Alec, official. So the Anti-Red Tape Act was actually amended to become Ease of Doing Business Act. The amendment was particularly on the period of response that must be done by the government offices or the government officials. Let's read the law. Section 3, coverage. All government offices and agencies, including LGUs and GOCCs that provide frontline services, of course excluding the judiciary, some quasi-judicial and quasi-legislative branches, and the legislature, okay, they must abide by the Anti-Red Tape Act, especially those who are, well, more so those who are providing frontline services. What are government offices that are into frontline services? BIR, because they're being visited by people all the time. What else? Census, NSO, of course, LGUs, those offices. Section 4. Let's define transactions. Number 1, simple transactions under Section 4 of the law. Simple transactions only require ministerial actions on the part of the public officer or employee. Ministerial meaning there's no need for the officer to exercise discretion. So therefore, simple transaction, it must not take so much time. That's a simple transaction. And the law, protects us from some government officials, uh, making us or delaying us, delaying transactions for some reason. So that's Section 4 of the Anti-Red Tape Act, amended as Ease of Doing Business Act. Okay, frontline service. Examples of that for those offices who are accepting applications for permits and licenses. LTO, right? LTO, or as we said, the engineering office, municipal engineer's office, what else? City engineer's office for applications of building permit, very much related to our topic. And of course, let's define action. Under the law, action means written approval or disapproval. Written, it must be written. Section 7, accountability of heads of office and agencies. All transactions and processes need to have been made with the permission or clearance of the highest authority having jurisdiction over the government office or agency concerned. This is as per what? As per command responsibility, because they are on the field. They are on the field. The rule of responsibility means field work. Will the president be accountable? Well, supposedly he is. When we talk of accountability on field work, command responsibility, it means responsibility to people on the field. The ground officer, the ground commander, for instance, when we talk of the military. Section 8, Item A, all officers or employees shall accept written applications, requests, and or documents being submitted by clients of the office or agency. So to avoid red tape, when you submit something there, they ought to accept it and not tell you, to come back or something like that. They have to accept it. They may require more, they may require you more papers, or they may give you more requirements, but you have to accept it. Section 8, Item B. Okay, they have to accept it by writing or printing clear on his slash her name, the unit where she is or he is connected with, the time and date of receipt. Now, this was actually amended in the Ease of Business Act. No, we will proceed. This was uh, amended, and the acknowledgement receipt that is required by the Ease of Doing Business Act, which is the amendment of the Anti-Red Tape Act, is the acceptance of the document submitted must be with acknowledgement receipt, which contains of the agency, name of the officer, the unit and designation of such officer, the date and time of receipt. So that's the requirement now. No longer just you know by printing or writing clearly name, unit, you know, office connected. Now we have to have seal of agency, name of officer, unit and designation, date and time of receipt. So that's the new law. Okay, let's proceed. Under the anti-red tape law, the previous law, the period stated, the period for the action, period for the government officer to act. They must follow the period stated in the citizen charter, which shall not be longer than 5 working days in case of simple transactions, and 10 working days in case of complex transactions. If simple transaction, it's 5. If it's not simple, complex, it's 10. But the amendment, the Ease of Doing Business Act, shortened this to 7 days. 7 days. We'll quote that later. Let's proceed. The office or agency concerned shall notify the requesting party in writing of the reason for the extension of the final date of release of the frontline services requested. So there must be written explanation of if there is need for extension. Section 11, violations. Light offense, refusal to accept within the period. If the officer doesn't want to accept, that's a light offense. Or failure to act on an application or request, or failure to refer back to the client or request a request, or failure to refer back to the client a request, which cannot be acted upon due to lack of requirement within the prescribed period. So there must be a period. Even if you were not able to submit requirements, the officer still must come back to you. Failure to give notice on the disapproval of the application or request. This is very important because what if the builder in your property was not able to acquire a building permit, and now you are requesting for information from the engineering office, and you want to know about uh, the building permit, whether there was or there was none. Um, if the engineer's office doesn't respond to you, then he is liable. So if he doesn't respond or he doesn't think you ought to have it because he thinks the document is not public or not for public consumption, there must be a written notice of disapproval of the application or request. So section 4 jurisdiction, Civil Service Commission, PAGC, and the Ombudsman. Okay. Now let's proceed to the amendment, the Ease of Doing Business Act. It amended the Anti-Red Tape Act last July 24, 2017, which now includes definition of the complex transactions necessitates evaluation in the resolution of complicated issues by an officer or employee, or said issues by an officer or employee of said government employee. In our case, if someone builds in bad faith on your property and you want to out the building permit, um, is that a complex transaction? That's not a complex transaction. The officer can easily, provide information as to whether or not such builder in bad faith had a building permit or not. Because in fact, if you are a person who built on someone else's property without a building permit, then you are a builder in bad faith. Section 9. Okay, item A3. Assignment of unique ID number for the application or request. So if there's application or request, there must be what? There must be an ID number for the application or request for easy identification and referral. So they can easily look for it among the files. There must be a ID number. And as we said, acknowledgement receipt. Okay, with seal of the agency, name of the officer, the unit and designation, the date and time of receipt. Okay, as we said, the Ease of Doing Business Act amended the Anti-Red Tape Act, and now we now have 3 to 7 days. Okay, no longer 10 days, but 7 days for processing time. The government office ought to make action within 7 days. Okay, 3 to 7 days. 3 if it's a simple transaction, 7 for complex transactions. Okay, also, item 2 must be appropriate action with a formal. There must be appropriate action or formal notice within the period. So the action must be appropriate and formal. So mean to say written. Okay. Another pertinent law is of course the RA 3019. RA 3019, more known as Anti-Graft and Corrupt Practices Act, a law that is quite regularly abused here in our jurisdiction here in the Philippines. Let's start quoting the law, Section 3, corrupt practices of public officers. What are the corrupt practices of public officers? Let's familiarize ourselves. Item E, causing. There's so many, but I quoted only one that is pertinent to our topic. Causing any, and let me recall. Some corrupt practices, if nepotism, relatives, consanguinity, etc. You hire them, nepotism. Also, when you you allow yourself to be bribed, okay? You allow yourself to be bribed, and you accept gifts, not moderate gifts, not moderate gifts for rejoicing or for special occasion, but or you you utter something, utter some words that in effect convinces your applicant, to commit graft and corruption. So it's the officer is the one, suggesting the graft corruption. Okay, there's more, but let's focus on the acts that's related to our topic. If someone builds on your property without due process, without proper permit, etc., causing any undue injury to any party, including the government, or giving any private party and any unwarranted benefits, advantage, or preference in the discharge of his official, administrative, or judicial functions, though through manifest partiality, evident bad or gross inexcusable negligence. This provision shall apply to officers and employees of offices or government corporations charged with the grant of licenses or permits or other concessions. There. This is actually the catch-all provisions because it talks about injury to a party, any party, okay, government, private. We have here the unwarranted benefits, advantage, giving advantage or preference in the discharge of official, administrative, judicial functions through manifest partiality, bad faith, or gross inexcusable negligence. For instance, a person builds in your land without building permit, and the municipal or city engineer fails to stop the person from finishing the construction. And when you find out the building is already completed, that's negligence, on the part of the office concerned. Item F, neglect or refuse to due demand or request without sufficient justification to act within a reasonable time on any matter pending before him for the purpose of obtaining directly or indirectly from any person interested in the matter some pecuniary or material benefit or advantage in favor of or discriminating against any other interested party. So this is somewhat like red tape because there's neglect, there's refusal after demand or request without sufficient justification to act within a reasonable time on any matter pending before him. But here, under the Anti-Graft and Corrupt Practices Act, the act, okay, has a purpose of obtaining directly or indirectly from any person interested in a matter some pecuniary or material advantage. But in Anti-Red Tape Act or Ease of Doing Business Act, there's no need for such intention. Okay, it's a mala prohibita. It's a mala prohibita law. So just by not acting on the, request, you are already liable. But here, the non-feasance, okay, okay, is with the purpose of obtaining directly or indirectly any person interested in a matter some pecuniary or money or material benefit or advantage. Let's proceed to the next law, the Republic Act 6713, an act establishing a code of conduct and ethical standards for public officials and employees. Also pertinent to our topic. Section 4, norms and conduct of public officials and employees. Political neutrality. So, public employees ought to serve the public regardless of political affiliations, regardless whether or the regardless of the applicants being Dilawan or being DDS, etc. And public officer must be responsive to the public at all times. Section 5. Public officer must act promptly on letters and requests within 15 days. This particular law, but now, as we know, under the Ease of Doing Business Act, 7 days from receipt thereof, letter, telegrams, or other means of communication sent by the public. So there must be prompt action. Otherwise, it's a violation of this law. For example, you want to know whether or not there is building permit, because there was construction on your land in bad faith without you knowing it. So you want to know if there is building permit. So there, the public officer concerned must, okay, under this law and so many other laws that we quoted earlier. Okay. Item E, make documents accessible to the public. All public documents accessible to and readily available for inspection by the public within reasonable working hours. So is a building permit a public document? It is a public document. In fact, when you have construction happening on a particular land, the building permit number is actually what? Is actually displayed therein. So it's a public document. Okay, let's talk about the building permits as per jurisprudence. Okay, under the in the case of Director of Lands versus CA, dated July 29, 1968, an old case but still a good case. The ministerial duty, according to Supreme Court, it is the ministerial duty of the city engineer to issue a building permit when the application and plans are in conformity with the requirements of building laws and ordinances, and as long as there is no violation of building ordinances in the process of construction, that official has no ground for suspending the building permit issued. The suspension or revocation of building permit without cause would be an arbitrary act and abuse of discretion. So therefore, if it's an discretion, the court can actually stop it. As per Rule 65 of the Certiorari. Okay, there's Rule 65. Mean to say it's a ministerial act to issue if all the requirements are complied with, and if the requirements are not complied with, then the officer must not issue a building permit. And if he does not issue a building permit, no construction should happen. And should it happen, he could stop it, and he could actually order the building to be vacated. Talk about that later. Under this particular law, National Building Code of the Philippines, 6540, Section 1, Item 20203. Any person, firm, or corporation, including any department, office, bureau, agency, or of instrumentality of the government, intending to construct, alter, repair, move, convert, or demolish any building or structure or cause the same to be done shall obtain first a building permit from the building official for whichever of such is proposed to be undertaken for the building or structure. So that's RA 6541, National Building Code of the Philippines. There's also presidential decree. This one is quite older. PD 1096, National Building Code of the Philippines. Section 207. This is still valid. Duties of a building official. Duties. So we said building permit is required. Automatically, the one constructing is in bad faith because there's no building permit. He he is the official charged with the duties of issuing building permits, the building official. Another duty of the building official, when any building work is found to be contrary to the provisions of this code, no building permit for instance, the building official may order the work stopped and prescribe the terms and slash or conditions when the work will be allowed to resume. Likewise, the building official is authorized to order the discontinuance of occupancy or use of any building or structure or portion thereof found to be occupied or used contrary to the provisions of this code. So we can order the discontinuance of the occupancy. Okay, you could also order the construction be stopped. You see? Mhm. Penal provision, section 213. This is serious, okay? It shall be unlawful for any person, firm, or corporation to erect, construct, enlarge, alter, repair, move, improve, remove, convert, demolish, equip, use, occupy, or maintain any building or structure or cause the same to be done contrary to or in violation of any provision in this code. Meaning to say, related to our topic, building without building permit is an offense under the building code. Okay, punishable by fine, punishable by imprisonment. Section 2000, Section 216. The rights, actions, and remedies provided in this code shall be in addition to any and all other rights of action and remedies that may be available under existing laws. Meaning you can still file civil case in addition to this case violation, a criminal case, which is a violation of the building code, can still file civil action or administrative action. Section 301 on building permits. No person, firm, or corporation, including any agency or instrumentality of the government, shall erect, construct, alter, repair, move, convert, or demolish any building or structure or cause the same to be done, first obtaining a building permit. Therefore, from the building official assigned in the place where the subject building is located or the building work is to be done. So, if you fail to actually obtain a building permit, then that is a violation of the building code and that is an offense punishable by what? Punishable by fine and imprisonment. This is in relation to our topic, which is if someone builds a structure or constructs a building on your land illegally, meaning without building permit. As we said, it's very important to have land in relation to prepping because prepping, which is one of the you know one of the contents of this vlog, uh, necessitates a kind of a bug out location, and bug out locations are very important during emergencies. what happened during the early stages of the coronavirus pandemic. People in Manila, okay, more especially in Manila during the lockdown, actually the entire Philippines, they couldn't move. It was very difficult. And how do you avoid the virus? So you avoid the virus by looking for a land, yeah? A kind of escape route, kind of bug out location where you will do your pagpapalamig. What if you get there, you find out that someone has already constructed a building or a house in your land? So we already read pertinent laws, and we just learned that in addition to the case that could be filed under the building code, the offense violating the building code could also file civil cases, which is under the Civil Code of the Philippines, the new Civil Code of the Philippines. But in bad faith, he is in bad faith because he knows that he's not the owner of the land, yet he built a structure there, or he knows that the sale, if ever he's trying to show you a kind of document showing some kind of a sale, he knows that the sale is invalid. He knows that the document is improper and in a mere scrap of paper, and yet without obtaining a building permit, this person built a structure on your land. That is, of course, already a violation, and he is already a builder in bad faith. And we already mentioned the consequences of being a builder in bad faith. You can be asked to remove the structure at your expense, and you have to pay damages. All right, that's all for this episode. On here for the Hagbayon Channel and TMS Talks. Remember, the pen is mightier with the sword. Legal knowledge. Thanks for watching.